everybody. Good morning. Nice to see everybody here. Let me give some shout outs. Leslie, Gulf Coast Girl, AJ, McCleary, Rebecca, Tammy, Rachel, Krista, Pixel. Good morning, Krista. Gulf Coast Girl, Alicia, BNN, Dawn, Shivani, hello, Leslie, BNN, hello, everybody. Nana, good morning, Karen, Titan. Sorry if I've missed anybody. Merritt, good morning. Afternoon? Good morning, good afternoon, good evening, depending on the time zone you are in. Good to see you too, Kathy, Fluffy Hedgehog, Crime Bee. Good morning, Chris. Just to let everybody know, I will be able to live stream from the courthouse legally. So just getting things set up here. That starts in about 10 minutes. Hello, Seymour, Shannon's, Laurel's, hello, Chris H, hello. We got St. Louis in the house. We got Ireland in the house. Sweden in the house. Leslie. Tisha is this afternoon. I'll be going live with that one at 3:15. Real Angel Girl, hello. Pepsi Girl, hello. Shannon, hello. So I am able to stream this live for you. Missouri, hello. Ireland. Puerto Rico. Wow, we got people from all over in here. Christy is still fighting COVID pneumonia. So awful. Yes, my heart goes out to you, my dear. Good morning, Tanya. Yes, please hit that like button. Let everybody know that we are live. 32 likes and 78 people in here. Come on, people, it's free. Mark Means has moved to Missouri. Yeah, we heard that he had moved. Got Arkansas in the house. Missouri in the house. Morning, Comp2. 85 viewers, 45 likes. Guess you guys really aren't that interested, eh? I'm just kidding. But I would appreciate it. Smash that like. Let everybody know. For some reason, it does help with the algorithm to let people know and people see that we are live. Leslie. Hello. Janice, Virginia. Woohoo. Okay, let me pop over to StreamYard so I can put some of these up here. Scotland. Virginia. Missouri. Arkansas. Puerto Rico. Willie. I'm trying to get everybody here. Stockholm, Sweden. So forgive me if I've missed you guys. I'm trying to catch up here. Gulf Coast Girl, good morning. Thank you for smashing that thumbs up. Titan, thank you. Estonia, Idaho, Frisco, Florida, Wyoming, Pittsburgh. Thank you, Christy. New York City in the house. Good morning, history. Lemonade, South Africa. Farah, my fellow Ontario, Canada. I'm up near Ottawa. So welcome, my fellow Canadians, too. Austria, Michigan. Good morning, AJ, Nana, Farah, Lemonade. Good morning, everybody. Stephanie, James Cooper. Dawn, Ontario, Canada too. BC, welcome to my West Coast Canadian. Belgium, Utah, Muskoka. Is that Muskoka, Canada? Pepsi, I think it is. Or California. So welcome to all my fellow Canadians also. Nice to see so many in here. Hello, Joe. No problem, history. North Dakota. Hamilton, my hometown. Hamilton, Ontario, Canada. My hometown. Welcome, Michelle. Orange, CA. Is that Canada? I know there's an Orangeville in Canada, just north of Toronto. Yeah, Hamilton, my hometown, born and raised. Suffolk, UK. Yes, Suzanne and everybody, all these cases worldwide. We're doing the Chad Daybell hearing live from the courtroom. Yes, I'm allowed to stream it, as you can see in the banner across the bottom. California. Okay. We have an Orangeville just north of Toronto in Ontario, Canada, too. So, and I don't know, Canada's abbreviation is CA also, so I get a little confused there. So thank you, Vineland, for, and I have a Vineland too, actually, right near Hamilton, Ontario. Vineland is just the other side of Grimsby, Hamilton area. Just east of Hamilton, between Hamilton and Niagara Falls. Yes, justice for Tylee and JJ and Charles and Joseph Bryan and Tammy. So as soon as this does go live, you guys, I will be bringing it to you live. Let me just pop over to my YouTube studio. Off topic, quite a protest by the truckers. Yes, it's been Shivani. It started in British Columbia, and today it is going through parts of Ontario. They are heading to, they hope to be in Ottawa by Friday or Saturday morning. So yeah, it is quite impressive. I've got a lot of friends and a lot of people I know that are going to be in Ottawa for that protest. Good morning, Roxy. Ohio, Sacramento, here we go. Good one. Good morning, cats. Tucson, Arizona. Okay, let me just check over here, you guys. Okay, let me jump in. Give me a second, you guys. Let me just refresh this here so I'm up to date. This should be starting any minute, you guys. We got about 4 minutes left to go. And like I said, once it starts, I will share my screen so you guys can all see it and hear it. Morning, Babs. Washington State. morning. Good morning. Letitia is this afternoon. I will be live with that one at 3:15 this afternoon Eastern. Yeah, at least we don't have to hear from Meads anymore. Today it's John Pryor. That's okay, hon. Suzanne is on all of our minds. They do have about 4 minutes left, Nana. I think they're both doing that, and they're both going to do that. I think with information that's come out, I think they are going to turn on each other. I don't think they have a lovey-dovey relationship anymore. Good morning, Wiley. You're very welcome, Mo Beans. Just bear with me while I'm keeping an eye on the courtroom to see when they start. I believe they're going to throw each other under the bus. Hi, Nay. How are you? Yes. Today is the anniversary of Gannon's death. You guys, I'm not going to be able to, until I get some mods in here, I may have to end up putting this over to subscribers only if this continues. I don't know where my mods are today. Eighty 168 people, only 86 likes. Come on, you guys, give me some likes there, please. Let everybody know that we are live. Okay, let me just do something here. Thank you for that, Babs. Let me just so yeah, I'm gonna have to stay in my studio, my YouTube studio, just so I can keep an eye on chat, you guys, until I get some mods in. I just sent a message out, so hopefully they get that. Hello, everybody coming in. Please smash that like button, get the message out that we are live, and that will also get my mods in here too. There she is. Thank you, Rosie. Rosie is a lifesaver. I've got one mod now. I've got Rosie. Rosie never fails me. Thank you, Rosie. My sister actually is getting dental work done, so she won't be able to be in for a bit. Thank you, Rosie. I got a mod. Hello, Ocean Surf Girl. Dawn, hello, hello. Laura. Sweet Caroline, hello. Rose, it's poor Rosie. It's 3:30 a.m. in the morning for Rosie. But Rosie, you're the only mod that's come in, so thank God you came in. I was just about to put it for subscribers only because I didn't have any mods, but thank you for getting in here. Okay, so let me check over here and see if what's going on here. Checking over here too. Okay, we're on our way. Okay, let me get this. They're just starting, so you're not going to miss anything.
Motions to be filed and heard under Rule 12B.
Judge, can you hold on for just one moment?
Yeah, who was that?
It's not letting me mute the YouTube, and so it's giving us bad feedback.
Okay, if you'll go ahead and get that resolved, we'll wait.
Okay, so can everybody hear it? Put one in the chat, please, if you can hear it. Right now, nobody's talking, but if you heard it when it started, please give me a 1 in the chat.
Do we need to say something so you can check it?
No. Okay.
No. Buffering, buffering. That's not me, that's the feed. Go figure, the one day that I can stream it from the court, they're going to mess up their feed. That's not me. No, it's them. They're buffering. Okay, let me stop sharing it and see if I can't. Yeah, they're going to start another feed. Hang on.
This is KCR 2221-1623, State versus Chad Daybell, representing Mr. Daybell is Attorney John Pryor. Rob Wood is here today representing the state. This is the time we have scheduled for a motion to extend time for motions to be filed and heard under Rule 12B.
Judge, can you hold on for just one moment?
Oh, God, here they go again.
Yeah, who was that?
Oh, it is the same feed. Hang on, you guys. Hang on.
Into the motion.
Yes, we do, Your Honor.
Okay. All right. I'll note that the arraignment in this case occurred on June 9th of 2021. There's been some fairly extensive delays because of preparation and obtaining of grand jury transcripts. And I know that was cited in your motion, Mr. Pryor, but at this time I will.
Can everybody hear it again?
On your motion to extend, so you can present.
Press
your
1 in the
argument.
chat if you can hear.
Judge, if you, in a review of the record, you will note that on 6/21 of 22, I filed my first motion to extend time. That was granted. Then on 9/21/22, still not having possession of the grand jury transcript, I filed another motion to extend time. Once I received the transcript, and my recollection is I received that sometime in the mid to late of October, I then had the 5 days of grand jury, and I'm not going to discuss the particulars of what's in the grand jury, but it was a significant grand jury transcript. I would say that, Judge, this was the longest grand jury transcript I have ever encountered. Part of the process of having to go through this was, one, having to read the grand jury transcript. Then I had to go back, Judge, and I had to review the preliminary hearing transcript of what each and every one of the witnesses talked about in front of the preliminary hearing in the original case. Then I've had to go back and compare the preliminary hearing transcript with the grand jury transcript and each and every one of the witnesses that offered evidence to the state that, at least to this date, has been provided to me. Judge, I will tell you that was a onerous task, and at this point, I just got, with stipulation of the state, to get the voting record. And I did manage yesterday when I was in Fremont County to take a look at the voting record. I felt that after the court did the initial trial setting, and I believe that was on 12/3, that under my reading of the rules is that I needed to file a renewed motion, a second renewed motion to extend time to be able to preserve that. Now, in reading of the rules, when the trial setting was set, at least my reading of the rules is that there was an opportunity within a short period of time, 28 days, to file a motion to dismiss. I don't think that was sufficient enough given the incredible length this motion is going to encompass. It's a significant amount of information in this, what's going to be addressing this grand jury proceeding. There are a number of issues that I'll need to bring up and a number of issues that I'll need to address. And Judge, it's not just something as simple as filing a motion to dismiss and saying this is what I have a problem with. This is 5 days of grand jury testimony. The standard, Judge, is excusable neglect, but there hasn't been any neglect here. What there has been, I've been diligent in going through all of this information, reviewing all of this, and quite frankly, Judge, the magnitude of the work is going to require that I'll need some additional time to do that.
And Mr. Pryor, I'll just note the rule allows for extension for either good cause shown or excusable neglect. So
Right.
that option's available under the rule as well.
And Judge, what I'm asking for is good cause. And frankly, Judge, I don't have any information, but I did contact Mr. Archibald, who represents Ms. Vallow, and I discussed with him, I believe in late December, that, I'd strike that, I think late January, late December, I'm in December, that I had heard that there was another grand jury proceeding with additional evidence that was presented to the grand jury. I contacted Mr. Archibald. I was advising Mr. Archibald had heard the same thing. I anticipate, Judge, asking for a transcript of that grand jury proceeding if in fact there was one. I don't expect Mr. Wood to address that or even acknowledge that. He doesn't have to. It's something that if he chooses not to acknowledge that it occurred, I'll petition the court for whether or not that there was a proceeding. But I did hear as part of the investigation that there was an additional grand jury proceeding conducted. So at that point, if there is, Judge, and there was any testimony as it relates to this case. At that point, I'm entitled to that information, additional information, and if there were witnesses and testimony, I should be afforded a chance to get that information prior to me even filing any kind of addressing any concerns I might have in the grand jury transcript. And with that, Judge, I'll hand this over to Mr. Wood.
All right, thank you, Mr. Pryor. Mr. Wood, state's response.
Thank you, Your Honor. I would note that in the defendant's motion, the reason for his request in the motion is simply that there was another grand jury proceeding. The state has no problem acknowledging there was a grand jury proceeding. The state does disagree that it affects this proceeding in any way. I would just note for background, Idaho Criminal Rule 12B provides that a defendant can file a motion to dismiss for defects in an indictment. There are time limits on that. Those time limits are provided by Rule 12D. And we've talked about already, it's 28 days after a plea of not guilty. The state in this case did not object to Mr. Pryor's first two motions. As has already been stated, the grand jury transcript was not prepared. That's certainly good cause for an extension of time. However, the state would further note that those timelines do exist, and failure to exercise those rights in a timely manner does constitute a waiver of such right. That's found in Rule 12F, and case law affirms that. I note State versus Jones, 140 Idaho 755 states that tardily raised objections based on defects in an indictment or information are waived unless they allege either a failure to show jurisdiction or failure to charge an offense. The defects for which an indictment may be dismissed are found in Idaho Criminal Rule 6.6, none of which were alleged in the defendant's motion, none of which have been alleged by the defendant today. In terms of the timeline of this case, I think we've already discussed that. I would note at this point, we are more than 90 days out since the defendant received the transcript. He has not filed any 12B motions to date based on that transcript. I would note he talked about the voting sheet. The defendant has only recently asked for that voting sheet, more than 2 months after he received the transcript. Now, we certainly, we did stipulate to him being able to see the voting sheet because the rules say he's allowed to. But if he wanted to base any type of motion, 12B motion on what's contained in that voting sheet or the transcript, he should have acted on that a lot sooner. He could have asked for that at the same time he made a motion to receive the transcript or when he received the transcript. Instead, he waited well past 28 days after the time he received the transcript to even make that request. Again, I would note the defendant has not alleged any defects whatsoever in the transcript or the indictment under which the defendant was charged. He hasn't presented any good cause other than it's voluminous. Well, he also alleged in his motion that he has read the entire thing. We understand there's a lot of work. Having said that, he hasn't done any of the motion work necessary to file any, to prepare for a 12B motion. In terms of this additional grand jury proceeding, he's never filed a request for that transcript. Now, the state actually believes he's not entitled to that under Rule 6.2C, which dictates who's entitled to a grand jury transcript. And I'm only noting this, Your Honor, because this is the reason listed in the defendant's motion. Grand jury transcript is limited to the prosecuting attorney, any individual indicted by that grand jury, or anyone charged with perjury due to their testimony in front of the grand jury. Mr. Daybell does not meet any of those criteria. Mr. Pryor is correct that grand jury proceedings are extremely confidential. The state does feel comfortable saying that his client wasn't even the subject of the grand jury proceeding that day. The only way that additional grand jury proceedings could reasonably be used to attack the initial indictment is if new charges were brought against the defendant and the state attempted to merge or combine those two indictments, which hasn't happened. Again, I've already brought up, he hasn't even filed a motion for that transcript. He only recently asked for the voting sheet. The right to file a 12B motion to dismiss an indictment for defects in the indictment protects the defendant's right to fair proceedings and a fair trial. However, the defendant's not the only person entitled to fair proceedings and a fair trial. The people of the state of Idaho, specifically the people of Fremont County and Madison County, are also entitled to a fair trial. The victims in this case are entitled to fair proceedings and fair trial. It would be unduly prejudicial for the state to grant the defendant, for the court to grant the defendant's motion, where he's clearly waived his 12B or his rights to file under 12B. We're more than 90 days out from the time he received the transcript. At some point, Your Honor, the problem is we're well into trial prep. We're getting ready for trial. Timelines are provided by the rules for these things to be taken care of in a timely manner. If Mr. Pryor had filed those other motions, we might have a different position, but he hasn't. They've made the tactical decision to not file any of these other motions. He has raised no allegations whatsoever of defects to date. And so in conclusion, he's failed to state any reason or good cause why any additional proceedings in which the defendant was not indicted should be subject grounds for an extension of time. He's provided no good cause in terms of actions he's taken to preserve those 12B motions. The defendant has not provided the court any excusable neglect for his decision not to do so. As such, as a matter of law, he has waived his right to file any 12B motions, other than those regarding jurisdiction or failure to charge an offense. So the state respectfully requests an order denying the defendant's motion, in which states the time to file any such motions is now expired. Thank you.
All right,
If I
thanks for
could
the
briefly
argument,
respond,
Mr. Wood. I'm going to allow a response. What did you say, Mr. Pryor?
May I respond, Judge?
Yeah, I was absolutely going to let you respond. You just didn't give me a chance. So
Okay, I apologize.
thanks for the argument. Mr. Pryor, what's your response?
Judge, I would point out that I filed a timely motion to extend time on 6/21/22. I filed another one on 9/21/22 because I had not had the transcript at that time. My recollection is that there was never a formal order extending the time, although I think on the record the court extended the time. At that point, I had not had an opportunity to review the voluminous nature of what was transpired here in terms of 5 days of grand jury testimony. So at that point, after he was provided the initial district court arraignment on 12/3, I filed another extension of time. I can't see logically how Mr. Wood can claim I wasn't diligent in seeking an extension of time because of the voluminous nature of this evidence when on 3 separate occasions, Judge, I filed motions to extend time. I take issue with Mr. Wood's suggestion that if witnesses were called during a grand jury transcript, and I want to thank Mr. Wood for acknowledging the grand jury. He didn't have to do that, and thank you for doing that, because there now will be a motion to get that transcript that of whatever was said to the grand jury. And Judge, if there were any witnesses who are witnesses in this case, now I would suggest that they probably called witnesses because they don't reconvene a grand jury and not put witnesses on the standard testimony. So anything that was said, the suggestion that I wouldn't be entitled to it, I think is ludicrous, because any information about what a witness says in front of any kind of a proceeding, I would be entitled to it. You don't get to cap this under some rule that says you don't get this. So if there now is grand jury testimony, Judge, I need that testimony. In addition, an opportunity to review that before I go forward with this motion. So I would respectfully ask the court to extend the time. I believe that the sheer nature of the volume in this case, and as an example, the court saw the voluminous nature of the venue information that I had to submit. I would represent to the court that that's only a fraction of what this case involves in terms of evidence. So given that, Judge, I think I've shown good cause, and I don't want to allege that there was excusable neglect, because there has been no neglect. I've been diligent in filing 3 motions to extend time, asking the court to give me an opportunity to adequately prepare this before. And Mr. Wood suggesting that I haven't alleged any problems with the grand jury proceedings. Well, Mr. Wood, that's not what a motion to extend is for. The motion to dismiss is to allege those things. And once the court provides me an opportunity and sets a deadline, if I deem that that motion to dismiss needs to come forward, it'll come forward. It'll allege what needs to be alleged. Thank you, Your Honor.
All right, thank you, Mr. Pryor. I've considered the arguments of counsel and the reasons stated in the motion. I've also considered Idaho Criminal Rule 12D, which goes through the time frame. I'd note that 12D reads that motions under Rule 12B must be filed within 28 days after the entry of a plea of not guilty or 7 days before trial, whichever is earlier. It goes on to state that in felony cases, motions under Rule 12B must be brought on for hearing within 14 days after filing or 48 hours before trial, whichever is earlier. And then importantly, it indicates the court may shorten or enlarge the time and for good cause shown or for excusable neglect may relieve a party of failure to comply with this rule. So going back earlier into the history of this case, there was an arraignment in the case that took place on June 9th, 2021, and a timely motion to extend was filed and granted by the court. There was an initial order on June 23rd where the court ordered an extension of the time and indicated that the motion was to be filed and heard by September 10th of 2021. And that was a time frame we discussed in relation to when we thought the transcripts would all be available to be a completed review to allow an adequate opportunity for the filing of a motion under 12B. As we learned later, then the transcripts were still not done at the time of that initial extension, which went out into September. And those transcripts, in fact, didn't get done, I believe, until October. There were intervening motions filed to preserve the request to extend under 12D. I don't find there's been a excusable neglect here because I do agree with Mr. Pryor's analysis that he's preserved the issue. And so the question before the court is whether or not there's good cause shown in this filing today. And I do find, first of all, that the rule obviously builds in quite a bit of discretion. And I think the policy of the rule is to allow the parties adequate time to bring such a motion well before trial so that everybody doesn't complete trial preparation and then find out a case is dismissed on the eve of trial. And I think one of the important things the court considers then is when is the trial in this case? And that's an important factor to me because our trial is still a year away. We don't have trial scheduled until January of 2023 in this case. And so due to the voluminous nature of the transcripts, I do find that good cause is shown for an extension. However, now that those are completed, the court is going to order a specific time frame like we did in the first order back in June of last year and set the hearing as well as the deadline for the motion. I just want to discuss the setting of the hearing, of course, because the rule then gives a quick time frame for the hearing to be heard after the motion is filed. So I'd like to include in an order the deadline for both of those. All the discussion of any further grand jury proceedings is beyond the scope of this hearing and not anything I'm considering, and I'm not making any ruling based on whether or not there was any further grand jury proceedings. All I know is there was no further indictment. So to me, that does not factor into this decision at this time. So with that in mind, there is still quite a lot of time before trial, but it's also a motion that I think has been out there and you've known about it for a long time, Mr. Pryor. And as you've indicated, you do now have the completed transcripts and you've reviewed those. So I don't know that this needs to get extended any longer than possible because I think the state is correct that it's entitled to know the answer to this question as it's preparing for trial, which it's already starting to do. So I will grant the motion and I want to now discuss a deadline for having that hearing and filing of the motion. And I'll note my calendar's a little tricky for the next, between now and March, although I do have some dates where I can get a hearing scheduled. So what is your suggestion on a proposed time frame when you'd have this ready to be heard, Mr. Pryor?
Judge, the end of March, I'm unavailable the 24th and 25th. The 29th through the 1st, I'm available if the court has any time at that point. that would be, that should be sufficient if the court can fit it in at that point. I do note that we do have another hearing on this case that I believe is set for the 18th of March. Actually, two hearings, one at 9 and one at 11. So I don't know that we should have it before that time, but obviously I'll defer to the court's wisdom.
I think this motion is really independent of those other motions and could be heard prior to that. So I'm looking to see if we could fit this in. I definitely don't want to do it on the 18th with those other hearings. I'm not sure how long the motion to sever will take, but I think we need to reserve time for that. I'm just, if you'll give me a moment, I'm just reviewing my calendar and what dates I don't have available due to other trial settings. How about March 23rd?
I can do the 23rd of March, Judge, yes.
Your Honor, is that the hearing date?
Yeah, that's, and I appreciate you bringing that up, Mr. Wood. I'm kind of going backwards here, but I'd like to get the hearing date scheduled, and then in accordance with the rule, we'll set a motion filing deadline. How does that day look on your calendar, Mr. Wood?
That day works for the state. That's the state's preference would be that this issue be taken care of before any other motions, though. Where it would be a dispositive motion, at least a temporarily dispositive motion.
Judge, I don't anticipate that the court's going to make a decision from the bench either on the severance or the other motions on the 18th. And frankly, having the motion 2 business days after that, I frankly believe the court's going to need some time to ponder all of these. And I fully expect the court could probably prioritize and decide on the motion to dismiss before putting any effort into its formal decision on the other 2. So I don't have as much concern that they're close in time as the court's going to probably not rule from the bench on all of these.
All right. I've considered all of that. I do find that the 23rd is a date that works for the court, and also in terms of the order of the proceedings in the case as well. So we'll schedule the hearing on the motion to dismiss for March 23rd, and then under Rule 12D, Mr. Pryor, then that will set your deadline for the filing of a motion of March 9th.
Thank you, Your Honor.
So if you'd prepare an order, Mr. Pryor, that indicates March 9th is the filing deadline for the motion, and the 23rd will be the scheduled hearing on the motion.
I will do that, Judge. And may I ask, Judge, I didn't hear what time on the 23rd?
Thanks. I believe I didn't mention that. So we'll just indicate that that will start at 9:30 a.m.
All right, Judge, I will get an order out, and you should anticipate getting those motions shortly.
All right. Thanks for your participation in the hearing today, both. Is there anything else we need to bring up this morning on this case, Mr. Pryor?
No, Judge, may we be excused?
Yes, Mr. Wood, anything further?
Not at this time. Thank you, Your Honor.
Okay, thanks, counsel. We'll be in recess.
Okay, so there you go. Just let me get my headphones and that off so I can hear myself so I'm not screaming at you guys. Okay, so what this was all about, there's 2 things. There's 2 grand juries that John Pryor was speaking about. Let me just close this out so it's not interfering. the first grand jury that paperwork that he talked about not getting. Okay, let me talk about that one first and get it out of the way so we're not getting confused. There was a grand jury that came back and sent Lori and Chad to trial for first-degree murder. Okay, that's the one that they are discussing in court today. But there's another one that Pryor brought up, that there was a new grand jury that had convened, and he has no information on it. He's just got wind of it, and he wants to know why he wasn't made aware of it and all that stuff, right? Well, what happened is there was another grand jury held, but it's only against Lori. That's in the death of Charles Vallow and possibly Joseph Ryan. Okay, so John Pryor would not be privy to that information because he's not part of that, and it's not joined with Chad Daybell. So he's not privy to that. Okay, so he's going to get nothing from that. He's not entitled to get anything from that. So let's get back to what happened today. So what Mark Means did, Mark Means, oh my gosh, why is that dummy on my mind? What John Pryor filed was a series of motions. He filed a motion to change venue. He filed a motion to sever. He filed a motion for the grand jury transcripts and the voting sheet, etc. He's saying that he still does not have all that. Although he does have the transcript from the grand jury, which he is entitled to, he doesn't have the voting sheet. So he wants the voting sheet before he makes any decision on what he's going to do and how he's going to proceed in this motion to dismiss. Because that's another motion he's filed. He wants the whole case dismissed against his client. So what they are doing now, there's a bunch of hearings coming up on Chad. Okay, so what they're going to do is they are going to have this hearing first on the motion to dismiss. Because if he gets his way and they get this motion dismissed, which I don't think is ever going to happen, the other motions will not need to be heard, which is the change of venue, motion to sever, etc. Okay, so Mr. Wood has to give over that information that's requested. John Pryor has read most of it by now. He needs the voter sheet and he needs another mini transcript of something. I didn't catch it. I was trying to get things figured out here in the chat. So he's given him until the 9th of March to make any other motions regarding that. Yes, he's filed a motion long ago to dismiss. So that's what's going to go on March 23rd. They are going to go through that motion. The first one, I believe, is going to be heard as a motion to dismiss, because if it's denied or granted, it's going to have an effect on all the other motions. So if it's granted and Chad walks free, they don't need any more court appearances. If it's denied, then he's going to go forward with the other motions, the change of venue, the motion to sever, and all the other motions that he has there, changing venue and everything else. So it was important that this was held today. And yes, the judge is covering all his bases. I do believe that, and you know me, you guys, I'm not for the defense at all, but I do believe that Rob Wood knew he was screwed on this. When it was brought up of the extensions, and I do remember those extensions, we all got a little upset when I jump in and get you guys all worked up about these motions that are supposed to be happening just for it to be put off. Well, that's what was happening last year. And the last time it was put off, what John Pryor kept doing was the right thing to do is to keep bringing it back and keep getting an extension so he doesn't run out of time to file that extension. Being that the transcripts weren't ready at the last request for an extension, he was granted that extension, what brings us to today. Okay, every extension, something has to be done within a 90-day period. So he was about running out on his 90 days. So that's why this hearing had to happen today, which now he was granted another extension into March, but that is going ahead March 23rd now. It's not a big deal, really. It's not changing the trial date. It's not changing anything that's really important. This is more housekeeping. It's more like, where's my paperwork? Okay, I got part of it, but I didn't get the voter list. You know, I guess he doesn't trust that the voter list is what they say it is. I don't know. But I'm sure coming from a grand jury, they're going to make sure that that list is on point. But anyway, and I'm sure the grand jury would have something to say about it if there was some kind of voting error that's been put out there. So it's just basically housekeeping, but it had to happen. But now he's under the gun. So now he's going to get that voter list today. Woods has to make sure he gets it. It was also said in court that he is not entitled to the other grand jury report because it does not involve him and has nothing to do with this case. That has to do with, I believe, the death of Charles Vallow and maybe even Joseph Ryan, which has nothing to do with Chad. So we'll see what's going to happen. It's the next hearing is scheduled for March 23rd. He has until March 9th to get all his filings in. So I will be watching the court file to see what is filed there and what he is planning on doing. He may see this grand jury report and go, oh, crap. I don't want to bring this into evidence and have it brought up over and over. I want to try and let people forget about that grand jury report, and let's just go on what the prosecution has. It's a touchy subject. They cannot directly lie to the court if they're asked something, but they're there to defend their client. So even if they know something that their client's telling them is a lie, they're going to defend them anyway. Well, thank you, Mel O. Thank you for subscribing and welcome. I think the March 18th is going to be extended to another date. I'll have to watch the court dockets because they want this one to happen first, where he's going to bring up the dismissal thing. So I think that they are going to wait until this decision's made on them. So those dates may change. Marie Burks, thank you so much. So much. Okay, so another thing that I've come across a lot, you guys, getting off the topic of this case for just a minute, is in the Barry Morphew case. A lot of people are asking about this fingerprint evidence, which could weigh very heavy in that case. I have been investigating it and looking into it. Who wants me to do a video, probably live, just on that fingerprint evidence, to go over what exactly it means, because a lot of people don't know about the difference between latent prints and how they collected them prints and how they can compare them on CODIS or APHIS. Do you guys want me to do a video explaining how this is all working and why those fingerprints to me really don't mean a lot? I mean, I shouldn't say they don't mean a lot. They do mean something, but and I don't know why the prosecution hasn't done this themselves. Maybe they are behind the scenes and we're just not privy to it. But there's a lot of things that go into that, especially when it's not a hit. A hit is when you enter a fingerprint into APHIS or CODIS, you put that fingerprint in there and it comes back and it says that fingerprint matches Joe Blow. Matches. When you put a fingerprint in and it comes back partial, that could be a series of anybody. Now, I can go in depth and show you that stuff and explain it all in better detail so you guys can, the ones that are having a hard time understanding why this is important for the prosecution and why I think it's not going to help the defense. It may cast a little bit of doubt if they use that information properly, which I believe they're going to, but There's some good points that the prosecution could shoot that right down with known scientific information regarding partial prints. You can put a fingerprint into CODIS or APHIS, put a partial, it could bring up hundreds of possible people that fingerprint could be. Hundreds. It just happens that one of those hundreds that could be is a sexual offender. But there could be hundreds others that also have that. So it could have nothing to do with that sexual predator. So I can go into detail and explain that and show you what I'm talking about in actual fingerprints. If you want me to do that, I can do it. Everybody's saying yes, yes, yes. There was more than 3. And that's what concerns me. Okay? And I'm going to tell you why. With this right here, Betty Smith. I'm going to tell you why. When the police got to the Morphew residence, there was no signs of anyone breaking into that house. So if somebody went there, okay, to break in to the house or her Jeep, there was no signs of forced entry into either. So what's that tell us? That tells us it's somebody known to Barry or Suzanne. Okay. Also, that house used to be used as a bed and breakfast before. Those fingerprints could have been left at any time. The vehicle was a used vehicle that they had purchased recently when they moved into that area or whatever. It wasn't a brand new vehicle. The vehicle went in for repairs and whatever. Could have been anybody's print. The bike shop, somebody could have left a print on that bike from the bike shop when it was in being repaired. And I know that was also a used bike that she bought. So that's what I said. I can go in and explain and show you guys on screen what I mean by showing you actual fingerprints and stuff, and why they can say that it is not a definite match. A latent print and prints that are on file, I can go into depth on that with you guys if you want. It probably won't be till next week because I've got my weekend full here. I've got my live on Sunday at 11:30 for you guys with updated information and the mini reads. So it will probably be, let me see my calendar here. I got Letitia Stout this afternoon. Excuse me. Was Letitia this afternoon at, oops. I'm not even in the right month here, you guys. Hang on a sec. I got Letitia this afternoon at 3:15. Barry Morphew is back in on this coming Tuesday. So it would have to be Wednesday, Thursday, or Friday of next week that I would be able to do that. Unless I find time to do it on Saturday. Betty Smith, yes. It really could have been anybody. Chad's pictures look exactly the same. And Lori, we don't have anything recent of her because she is in a psychiatric hospital and nobody has access to her. How many hours is that from you now, Willow? Right now, it's in, well, I'm at 12:15. I'm going to be going live at 3:15. So in 3 hours from now. I do believe that it was brought up. And I know there was, Cahill is going to be on the stand February 1st. I'm interested to see about that before I really make a comment on that. But I do believe that the DNA fingerprinting was brought up in the prelim. Thank you, Roberta. Thank you, Rosie. Thank you, Terry. Now, let me just scroll up in the comments here, you guys, and see. Dana, it could have been almost anybody. It's a partial, which could come back in CODIS and APHIS. There could be 1,000 people that come up with that partial, that have that partial. That's not a good thing for the defense. And the prosecution, I hope to God, jumps all over this. This is their chance to shut that down. Hello, Mama 4. Yes, the prints are a match. It's not a hit. There's a big difference between a match. A match could have thousands of profiles come back to it. Whereas a hit is dead on. That is the person who owns that fingerprint. So there's a big difference, you guys. So I am going to do that and go over it with you guys, so it's more understanding for those who really don't understand how it works. I will have photos to show you. I found a really good place to get you the information that is going to explain it the best. Okay, so I'm going to let you guys go for now. I explained what happened this morning the best that I can. We will see what happens. We'll see if the March 18th hearings still go on, or the 9th and the 11th. We're going to see. I will keep an eye on the docket. I also get text messages of any changes. Some of them, they don't change it to the day of. So let's see what's going on. I'll keep an eye on the docket, and I will let you guys know. Always try and check my community tab, because I generally put anything that's coming up, I will put in there a day or so before. So later today, 3:15 Eastern, which is in 3 hours from now, I will be live with the Letitia Stout case. Okay, so until then, you guys, thank you for my mods for being here. I was getting a little worried there when I seen no mods in chat. Rosie was first to show up, and then Cindy and everybody. Thank you for, and Corey and that. Thank you for showing up. I really appreciate it. So I'll see you guys all 3:15 this afternoon, in 3 hours from now. I do have the link to it in my community tab. If you click on that, you can click on the reminder to make sure you're reminded of it. Okay, so I'll see you guys all there. Love you to the moon and back. Bye-bye for now.